AI phone calls could get you fined $1,500 per call.
The TCPA gives these statutory damages of $500 to $1,500 per call or text.
And this lawyer says most businesses are breaking the law without even knowing it. But there are smart ways to go about it. And since I build a ton of AI agents that does phone calls, SMS, emails, and social media messaging, I realized there's a ton of confusion about what's actually legal. That's why I brought in a top lawyer to clear everything up. In this video, you'll learn how to use AI calls and texts the legal smart way, how to protect yourself from massive fines, the safest ways to use AI for communication. Joe actually defended hundreds of companies in phone lawsuits over the last 20 years. So whether you're using or even building AI agents, these next few minutes could save you in thousands of fines. Hey guys, so I've been doing a lot of the AI calling and texting in this space, and I realized a lot of people have like legal questions on what is actually legal or not, and there's a lot of confusion right now. So I actually brought Joe, who very kindly actually is here to help us out. I just want him to take over, say a bit about himself, where you can find him, and we can get into some really cool questions that a lot of people had. So Joe, great to have you. We'd love to learn a little bit about you.
Sure. Thanks for having me on. My name is Joe Bowser. I'm a partner at a firm called Roth Jackson. We have offices in Tysons Corner, Virginia, and Richmond, Virginia. And I have been practicing telecom and TCPA defense for over 20 years now. So my work looks at calls, text messages, and other communications technology through two primary lenses. So I'll represent carriers and platform providers. So whether it's phone companies, UCaaS providers, or text message platform providers, on the one hand, dealing with the TCPA compliance of their customers, and then interfacing with government agencies like the FCC and state attorneys general. And then I represent the various heavy users of those services in TCPA compliance and defense in court cases, typically in federal court, and typically class actions.
Damn, that's heavy. I guess, yeah, there's so much going on in the space. We'd love to learn more. And I guess what I realized is like everyone learns best through kind of like examples.
Mm-hmm.
So like I'm trying to find like good business sweet spots and what we can do. So let's say someone is using AI technology, right? So now it can make phone calls, you can do text messages, automatically follow up, right? Do you
Sure.
have just a blanket opinion, or what would you say is the most safest and most effective way to take advantage of this?
Well, if you're trying to avoid TCPA exposure, because TCPA only regulates outbound communications, inbound is the safe place to get comfortable and experiment. So if you'll give me maybe 2 minutes, I can explain the TCPA and its structure, because it's not this monolithic or simple thing, right? Mm-hmm. So the TCPA has two main parts.
Wait, sorry. What is the TCPA at all?
Okay, so
we should do that.
Sure. That's the Telephone Consumer Protection Act of 1991. It is a federal law that governs the use of technology and telemarketing. There are other federal laws that govern telemarketing, like the FTC, Federal Trade Commission's telemarketing sales rule, and then the panoply of state laws that have mini TCPAs. So today we're going to, they can get complicated, but today we're going to just focus on the TCPA, so the Telephone Consumer Protection Act of 1991. Back then, most of you probably were not even an idea, but take it as true that family dinners were regularly interrupted on house lines, right? Because that's all there was, unless your dad had one of those very cool bricks in his car, right? Fascinating. So everybody got annoyed at having to get up during dinner and answer the phone, and it was a stranger telemarketer. Frustrating, whatever, right? So Congress says people have a right of privacy in their home telephones. And we're going to task the FCC with promulgating regulations that restrict this. So it's got two parts. The first part is 227B, 47 USC 227B. A has the definitions. You can read them if you want. So 227B governs callers or texters, shouldn't be texters, but it is, use of certain technologies, three of them: artificial voice, which will be AI for today's purposes, pre-recorded voice, and an automatic telephone dialing system, which is a very well-defined term that the Supreme Court finally resolved a humongous fight in the courts about what that meant in 2021. And it now basically means a dialer that hopefully no one is using anymore, because the dialer has to be randomly or sequentially generating the numbers that will be called, which hopefully nobody does anymore, and doesn't use technology that does that, because you as the user or caller or texter are gonna supply the list of numbers that will be called or texted. So that 227B, in light of this, the case was called Facebook versus DeGuide. So we're now under 227B left with restricting artificial and pre-recorded voice calls to certain kinds of telephone lines, the most important one of which is cell phones. Okay, so cell phones were just getting rolled out in 91. People were paying crazy amounts per minute to receive a call, and they just didn't want any of that type of traffic hitting the cell phone networks, unless you gave prior express consent. Okay, so that's what it looked like in 91. And then they separately said, FCC, lots of these calls are telemarketing calls. They call them telephone solicitations. I want you to make regulations in the next year or so prescribing the types of telephone solicitations that Americans can receive and object to. So in that year's time, all the FCC did was create what are called internal do not call lists. So if you were Macy's or whoever, and you were calling saying, hey, why don't you buy my sweater or plates or whatever, you could say to Macy's, hey Macy's, I don't want to get your sales calls anymore. Please stop calling me. And starting in 92, Macy's had to honor that internal do not call request. There was not a national do not call registry until 2003. Because the FCC didn't create it, Congress got impatient and told the FTC to create it. And then the FCC had to create parallel rules to sync up with the FTC's administration of the National Do Not Call Registry. So anyways, fast forward to today, the FCC has made a number of changes, some with regulatory authorities, statutory authorities, some not. But anyways, now, if you are making telemarketing calls of the pre-recorded or artificial voice variety to cell phones or landlines, you need a heightened form of consent called prior express written consent. So it's the kind of thing that you would see on a website or other, opt-in page where like you pop in your number and you say, I consent to receive pre-recorded or artificial voice calls at the number I've provided. I understand that my consent to get those types of calls is not a condition of buying your stuff or services, right? So that's what prior express consent looks like until January 27th of next year. The FCC issued a new one-to-one consent rule. So they thought that American consumers were getting tricked into giving too much consent to get these calls. So sites like LendingTree and other comparison shopping sites were effectively getting consent for lots of marketers to call you about any number of subjects when you were going on to these comparison sites, and they wanted to close the so-called lead generator loophole. So now, starting in January of next year, if it doesn't get reversed on appeal, and there was just oral argument yesterday, I think it was, in that case, prior express written consent starting in January is going to have like finer tightening where only one identified seller per checkbox can get that consent to get the AI or artificial voice or pre-recorded voice calls. And then those calls have to be logically and topically related to the consent that it was given in, right? So today, if you give consent to like get a financial product, you may get calls about education, because people who are looking for financing may also want to improve their earning potential or whatever. But the FCC is trying to tighten up the types of calls you can make with your current prior express written consent. So anyways, like that's at a high level, the TCPA, and we have a very incoherent marketing law at the federal level. Like you can pay the federal government all the money you want to drive polluting trucks to deliver, polluting paper into your private mailbox, right? You have no right of privacy. If you pay the federal government to carry your crap, they will stuff all the mailboxes, right? And the CAN-SPAM Act governs email. And you can comply with CAN-SPAM very easily. You have to, say who is the sponsor or the sender of the message, give your address, and have a functioning unsubscribe button, right? So U.S. mail, like mail advertising and email, have a fairly easy to comply with regime, unlike the TCPA. The reason TCPA gets in the news so much is because Congress gave what's called a private right of action, a right to sue for statutory damages. So unlike, lawsuits of old where you actually had to prove you were hurt and how much you were damaged, like you actually have to prove, like if you get into a car accident, you have to prove, my bumper cost $2,000 to fix and I spend another $2,000 at the doctor's office, right? Bam, I'm owed $4,000, right? But the TCPA gives these statutory damages of $500 to $1,500 per violation. So the TCPA has two parts, so you can violate both sections in one call or text. And so the plaintiff's lawyers love it. You don't need expert witnesses to prove anybody got hurt. No, you don't have to pay the doctors, right? So Congress created a feeding frenzy that really took off, maybe 15 years ago. And there is a cottage industry of both professional plaintiffs and plaintiffs firms that are looking for, the next big case for TCPA exposure. So in maybe 3 minutes or less, there's, TCPA at a high level.
Awesome. Okay, that is a really good insight. Thanks for that, Joe.
Mm-hmm.
So you mentioned the fines. You said $500, right? And
per violation.
Sorry?
Per violation.
Per violation. Okay.
So per call or text. Mm-hmm. So the TCPA doesn't mention text, but the FCC basically said, when Congress wrote call, they really did mean text message too in 1991, even though text messaging was not a commercially available service when Congress passed the TCPA. But, in their, spiritual interpretation, they figured that that's what the Congress would have done. Now, we're in a very different judicial oversight climate these days. So we'll see how much longer those sorts of interpretations last. But sitting here today, the DNC rules apply to text messages. It is much harder to have an auto dialer case against anything because there really shouldn't be auto dialers in use today. And if you're not using MMS that automatically plays a voice, like SMS and MMS really just shouldn't be subject to the 227B rules, which are the more common target for the plaintiff's bar. So if you're doing SMS today, the section of the TCPA to really focus on are the DNC rules. But carriers, as everybody hopefully knows, the carriers have a lot of control over the SMS ecosystem, and so they require you to show your basis for consent before you even get a 10 DLC number, a toll-free number, and a short code. So it's harder to get onto the peer-to-peer type messaging platforms without having a consent-based campaign. So SMS is just the safer place to be these days.
Interesting. SMS is the safer place to be these days. Does this have any difference if it's a business or if it's like just a random consumer?
So the DNC rules only apply to telephone solicitations to residential telephones. Mm-hmm. The FCC has recently said that residential phones are also cell phones now, even though Congress knew how to say cell phones when they wanted to say cell phones. So anyways, but they have conceded from the beginning that residential does not include business. The challenge is, many business owners, like me included, use their cell phone all the time for work and personal. So it's often a mixed question of fact how a phone is used. So it does make it hard to get class certification in class action cases, But so the short answer to your question is business phones are not subject to the DNC rules. The nuance and the devil's in the details is how is any given phone used, right? Because there is no like perfect database of business phone numbers. So what one can do is scrub out wireless, right? So there are commercial services to scrub, like DNC.com has a commercially available wireless scrubbing service. You can scrub out wireless and then, use other analytical tools to try to isolate business numbers. Lots of alchemy goes into those processes, but I have clients that have successfully navigated that and only, very rarely get someone who says you've actually called a residential line, but often it's a VoIP line that, VoIP is this, regulatory gray area itself. And so some of these things are just going to, hide in the cracks.
Interesting. So technically, what I'm trying to understand is what happens to these fines if it's a business number. Let's say they use it a lot for business, let's say, right? And someone is cold SMS or text for calling them.
Yeah. Well, they need to successfully secure it from that party in a lawsuit. It's not a fine. Like the FCC and state attorney generals have authority to enforce the TCPA. That is far, far less frequent. The overwhelming 99% of TCPA cases are private plaintiffs suing private defendants. So it's not a fine in the sense that it's like a speeding ticket. It would be damages awarded in a civil lawsuit. So they'd have to prosecute the lawsuit, win, get a judgment, and then go collect. Or obviously, far more often, the parties just settle.
Okay.
Right? So, there's professional plaintiffs who send demand letters, right? There are, plaintiffs firms who are just vacuuming in claims. Like they have apps where you report unwanted calls and then they can generate a demand letter for you, or they'll make you a client, or, like there's a cottage industry of these folks trying to generate claims and,
Generate claims. Interesting.
Well, there's certainly a phenomenon of folks who litigate often, and it is, very difficult to understand how they are getting so many of these phone calls without putting their phone number on, calling lists. And I've definitely litigated, against professional plaintiffs where it's very difficult. If you're using a VPN or you go to a public library and you stick fake names and addresses into an opt-in site, but your phone number is right, you are going to get those calls. And then when you, pretend surprise and indignation, you're going to send a demand letter saying, I got 10 of these text messages or calls. I didn't consent to this. I don't know who did, right? And so you're then left having to prosecute a counterclaim for fraud, which is, quite hard to prove against some of these folks if they, if they're using these sorts of blocking and tackling techniques that make it difficult to prove. But, some courts have successfully, punished professional plaintiffs for manufacturing TCPA claims.
Interesting. Okay. Yeah, I didn't even think that people would be trying to manufacture these suits like that.
Well, with that much money on the table, right? And lots of folks like competent, good TCPA defense attorneys are not free. So, many of my clients have to decide, am I going to pay a cost of defense settlement and just get this out of my hair, even though they did nothing wrong, right? Like they may not have even made the call. They have no idea what you're talking about. But proving those things, if you have to get through the discovery phase of litigation, that can be a year of your time and, defense counsel expenses, et cetera, et cetera. So do you pay some knucklehead $1,000 to go away, or do you, defend your name at whatever cost? So there unfortunately is no fee shifting statute, like there is no fee shifting clause in the TCPA. And the so-called American rule in America is each side bears their own attorney's fees unless there's a contractual provision that says otherwise or a statutory provision that says otherwise. And the TCPA is just the, congressional feeding frenzy for this kind of stuff.
Interesting. So I guess this, to take it in a specific example, I've noticed this happen a lot. Let's say someone is a realtor, right? They're technically a business. So and then I'm assuming they would use their phone for both their personal and their business most of the time.
Yep.
So let's say, I just want to cover both options. Let's say they opted in, they went to some site about their information, they put that in,
Yeah.
and then we're calling them. That's one. The other one, yeah, that's fine, right?
Well, so you want it's totally fine for DNC purposes, right? So the DNC opt-in can be very flexible, right? You can even have what's called an established business relationship, and that's an exception to the DNC rules. If you're gonna use regulated technology, AI voice, artificial voice, pre-recorded voice to call that realtor, then you need to make sure that your opt-in complies with the prior express written consent rules. Right? So there's two different kinds of consent that you have to think about depending on the type of technology you're going to use. But if you're just going to pick up the phone and make a live agent sales call to that realtor who opted in, that's a legal call. Subject to you, like, not harassing them or, saying something that's false and misleading, et cetera, right?
And if what happens if, let's say, they didn't opt in, but they're a business? So if I'm just like, I find them from some database and I'm calling them.
So, right. So then you're going to have a fight about whether that number really is a business number, right? So like they should have to prove that it is a residential line. So not all courts have resolved this question. The Ninth Circuit Court of Appeals, which covers the West Coast, like California, Oregon, Washington State, they have said that cell phones are presumptively residential and you can overcome that presumption. Other states just say, other courts just don't have a presumption one way or the other. So that's a great fact for you to have that they pepper their, phone number all over the web. I have all of these cases, like all the time, and they still say, well, I still, text my wife with it or whatever, right? It like comes home with me. And you've got to fight about that. Right? Now, those cases are very difficult to get class certification, right? Like those are the cases that hurt, right? So if a class action gets certified against you, that's not where you want to be, right? But if some plaintiff has a 2-call case against you, their maximum damages is $3,000. Like, is that really, like, that is just a socially wasteful exercise, right? Like, hopefully we can all agree that there is something better to do in life, right? So that should settle very quickly and just move on, right?
Okay. And I guess what I've realized is it might become hairy here. Let's say they did give you consent, right? And what happens if, let's say, you call them, you text them, and then keep following up? What I'm trying to understand is, like, how long can you keep doing that?
So consent is valid until it's revoked. Okay? So, and it can be revoked by any reasonable means, which is like a kind of modern spin on it. Like brands used to try to channel revocations of consent into easy to track ways because like some people would, send these like bizarre poems by text message that if you spoke this, convoluted language and read it carefully, you'd be like, that person probably wants to opt out. And then they go and sue you when you keep texting them. And so anyway, so that's like a frustrating use case and which the FCC kind of validated recently. So anyways, consent, like written consent is valid until it is revoked. And if you have what's called the EBR, the established business relationship, those have a regulatory life cycle. So if someone calls and makes an inquiry, like, somebody calls me and says, hey, Joe, I'm interested in your services. Like, and it's a consumer, right? It's a residential line. I don't have human being clients, but let's pretend I did. Like, they would, like, if I called them back, I get 90 days for an inquiry EBR, right? Unless and until they tell me, hey, Joe, I hired somebody else or whatever, right? Then I have to log that internal do not call request and respect that indefinitely, right? And if they sign up for service, then I have 18 months from the life of the transaction for the EBR. But if it's a written consent, it's good until they revoke it.
There's no limit of how many times you can message them or anything within that time frame?
Well, there are outer limits, like so the FTC has like a no harassing rule. There's no like fixed number there. Um, the FCC has certain, like there are certain kinds of exempt calls, like fraud alerts, et cetera, like nonprofits that are not subject to like certain of the rules I've already talked about.
Hmm.
So there are some call frequency limitations, like the 3 calls per 30 days for the nonprofit exemption. So like you can't get bombed with the political stuff. You shouldn't anyways, but you do. Yeah. So anyway, so there are some call frequency restrictions. It very much depends on the use case. Um, SMS, like you want to be guided by a good user experience. Like, why are you going to pay to annoy people?
Yeah.
Right? Like that's just a bad user experience, right? They're like probably not going to be a customer, right?
Yeah.
So there's like practical reasons not to do some,
Hmm.
unwelcome things.
Just curious, does this apply towards other ways of contacting people, such as, I don't know, let's say WhatsApp, Instagram, social media, etc.?
Great question. No, it's about phone calls, which has been expanded to include SMS. The TCPA also covers fax, FAX. You guys can look that up. But anyways, it's still a thing for like medical practices and stuff. But so the TCPA only regulates phone calls, SMS, and fax. So
Interesting.
so stuff that doesn't hit the so-called PSTN, the public switch telephone network, or mobile phones, um, doesn't count. So like if you're messaging in app, like just like if it's an SMS that hits iMessage, that counts. But if it's like WhatsApp to WhatsApp and it's not hitting your 10 digit telephone number, then it doesn't count.
Huh. That's interesting.
So,
Okay. And I guess these apply to businesses that, for example, let's say they might have a lot of old stale leads that, let's say they haven't gotten around to talking to or reaching out to, right? So, what would you say if, let's say, there's a business that ran a lot of ads, but they couldn't get the time to follow up with all these leads? What can they use this technology to potentially do? Because they're
well,
opted in.
well, it depends what the lead like is, right? So we've already talked about, do you have prior express written consent,
Hmm.
just prior express consent, or some other interaction, like you met them at a trade show or whatever, right? Like, so you need to know what that opt-in looks like to know what your communication rights are. Let's just say these were people that you met at a trade show and you got their card,
Hmm.
right? So they didn't opt in with the prior express written consent rules. You have their card, right? You met them at a booth. If it's within 90 days, you arguably have that inquiry EBR. You can do what you want without the regulated technology, right? Because you didn't get prior express written consent to use AI, artificial pre-recorded voice. So you can make live agent calls to them or SMS within those 90 days. If it's past 90 days, you really should scrub your list against the national DNC because they are effectively strangers at that point, right? Or if you just buy a list from a lead gen, right? Like you get these people like go around selling scrubbed lists or whatever, like do not believe that. Like scrubbed for what, right? Scrubbed when? Who opted into what? Like if there's just so many questions that come with kind of generic lists that like it may be relevant to you. Like these are people who are who shopped in your vertical in the last 6 months. Like that's interesting, but they are strangers to you. So unless and until you get the right level of consent to use the right type of technology, you really should be using DNC scrubbing tools to make sure that you're not sending sales communications to these folks and not using AI or pre-recorded or artificial voice at all to those numbers, if it's a sales communication, because you can't do that to strangers on cell phones or landlines.
Interesting.
So if you can
So,
thread the business to business needle, great. But
oh,
otherwise, I would, scrub and use live agents.
yeah. I'm surprised that live agents can do it. Like, even if you employ someone in overseas.
I have a lot of clients who do that. That's, yeah.
Yeah. So, what about email? Like, I see so many people doing a lot of cold email, right? This
Hmm.
is either to businesses or consumers, I think.
Yeah. So, like I said at the top of the show here, like canned spam is very easy to comply with. Like there's just a few, you know, few rules. Identify yourself clearly, nothing misleading, give your address, a functioning unsubscribe, and just it's pretty straightforward. And you have to actually prove damages if you're going to sue for violations of the Canned Spam Act. So there isn't this like statutory incentive to just hammer people for mistakes.
And what happens if, let's say, for example, you do this cold email and someone's like, yeah, I'd be happy to talk. And let's say I have their phone number. I got it from some list. I'm making up scenarios. Can I potentially call them with the AI agent?
I mean, they didn't provide you their number, right?
Let's say they
So
did or didn't. I'm trying to get the, you know?
yeah, I would think carefully
Mhm.
about the extent to which you actually know their number,
Or
right?
at least
So
sometimes their number will be on the, what's it called? On their
on the
email
email footer.
signature. Yeah.
Um, interesting. Interesting. Maybe there, I would feel safer with SMS, right? Because you've got the inquiry, right? You've got a written inquiry coming back. Like emails can be unsolicited. That's
Hmm.
that's fine. Like you just have to do the blocking and tackling to comply with canned spam in terms of the name identification, address, disclosures, functioning unsubscribe, etc. So, like as long as you're checking those boxes, those can be unsolicited. Now, whether it's going to get through the Gmail filters, et cetera, is a different story. But but that's fine if they write back with a phone number and say, I'm interested in your solar vacation package or whatever, and you call them about that. I could, that like there is a compliant use case to explain there if they're writing you back with their phone number and ask for more information.
Oh, huh.
But not with AI pre-recorded artificial, right? Because you haven't gotten that heightened level of prior express written consent, right? You what you got there was an inquiry,
Hmm.
right?
That's a good point.
Right. So you always have to be careful to use the technology that you were given permission to use. And it's not always the same thing,
Yeah.
right? But if you do get prior express written consent through an opt-in form, you know, Facebook ad that they filled in, whatever, then yeah, then whatever is good for AI pre-recorded artificial voice is gonna be good for DNC.
Okay, interesting. So you mentioned the Facebook ad. I guess that's a very common thing people do. They do a Facebook ad to an opt-in. If people have that, they opt in, and then you can start doing it very safely for a specific amount of time, at least.
Well, if the opt-in is set up and architected correctly, where you really are getting the TCPA compliant prior express written consent, that consent is good for you until that called party revokes it. One asterisk there is the longer ago you got the lead, the higher the likelihood that that person may actually lose that phone number. So there's this thing called the reassigned number database.
Hmm.
The latest stat I saw was like 36 million Americans a year change mobile numbers, which sounds crazy, but like that's the data. So if I gave you consent, a year ago, and I'm one of those 36 million people, and that number gets reassigned to another user, that other user did not consent to you. And unfortunately, the TCPA is typically interpreted to be a strict liability statute. So they don't care that you had consent a year ago, right? So the FCC tried to deal with that inequity recently by creating this reassigned number database. It tends to be expensive. It's like volume based on your volume of API queries to the database. But anyways, there is a fix now for that problem. Not necessarily cheap, but something else to keep in mind.
I guess that's why, and I preach this all the time. I guess speed to lead is so important.
Yeah.
Yeah.
You gotta
How
go
do
with
you
the
kind of
temperature.
see the future shaping out in terms of like how, everything might change because we have access to these kind of technologies right now?
I mean, so much of what I do is what Yuval Harari calls an intersubjective reality. Like these are just fictions built on fictions, right? Like I've already described the totally incoherent, marketing legal regimes, right? So I would be a total idiot to tell you that it was going to make sense anytime soon. So if past is prologue, it's going to keep evolving in a, fairly incremental ad hoc way. The FCC did issue what's called an NPRM, a notice of proposed rulemaking to deal with AI. This was in February, I think it was. They're still taking comments. We'll see what the Trump FCC does with this. Like, things absolutely change at federal agencies when there is party turnover. So we'll see what happens. But they're proposing new, disclosure and consent rules that would make it a little more clumsy to get consent for AI calls. I mean, I think it's gonna have to take consumers saying, like, knock it off. Like, I would rather talk to a bot than some low-level, poorly paid person in the Philippines. Like, if that's a better user experience and you're having a more effective, more efficient experience with the bot, like, we may just have to have some pain where these companies just lobby together and say it is better for everyone if we stop making this so painful to get these types of ornate consents that are traps for the unwary and just windfalls for the plaintiff's bar. So why don't we start to get a regime that makes some sense? I'd love to go do something else, and we can get a more coherent regime that doesn't favor polluting our mailboxes with stuff, and get some common sense, streamline rules about how to consent and opt out.
That's awesome.
But
And
nobody's making me president.
oh, do you have any thoughts on what might happen, or it could just be predictions or anything with the new administration coming in, or maybe how we should be prepared at the very
So, for good or ill, like robocall mitigation is a bipartisan issue. Like nobody likes it, and unfortunately, bad apples make bad law. Like as long as scammers are going to keep using this channel, it's going to keep being hard for legitimate businesses to also use it, right? Like it does pain me that my grandpa gets these kinds of calls. It is annoying, right? Now, how I don't see those really mitigating, right? Because those folks are offshore. There's some technology on my carrier side that is helping stem the tide of that in terms of stir shaken, call authentication rules, that's outside the scope of what we're talking about here today. So if we can get some technological solutions like we got for email, our inboxes are far more uncluttered today than they ever were, right? So if we can get that to work for voice, that would be wonderful. It is very difficult, right? Because you don't know what people are going to say. So unfortunately right now, regulators have some very unreasonable expectations of my carrier clients. Until someone opens their mouth, you don't know what someone's going to say on a call. So the idea that you can mitigate it ex ante is just silly and not realistic. But anyways, so with respect to the new administration, I do think that they will be more purposeful about what the agency can do under its existing statutory authority. Because the current FCC has basically used its TCPA regulatory authority to turn horses into unicorns, right? To say that a call is a text message, who talks like that? right? Like nobody, right? Like not even my grandpa would conflate those two things. So I do think that the Republican FCC will get clearer. Will hopefully try to get clearer enforcement authority and like rulemaking authority to get some like actual like legislative process in place to say, okay, agent like FCC, here is your authority. Here are the goals we want you to accomplish and the tools that you have to use it. So, but like the idea that Congress is gonna, produce those outcomes, I would maybe not make that bet.
That's all. Yeah. Thanks for your thoughts, Joe. That's actually super illuminating. Lastly, actually, this was I learned so much that like I'm like processing everything. I just wanted to say like, if someone's having problems like these or I just want to know where can they find you so you can potentially help them out.
I am a partner at a firm called Roth Jackson, so it's rothjackson.com. I'm a privacy lawyer, so I don't actually have social media. I hope everybody has read their privacy policies. You are giving it all away. So I just have LinkedIn. You can find me there and on my website, jbowser at rothjackson.com. I keep it old school.
This is awesome, Joe. All right, Joe. It was really great having you. Thanks for being on.
Yeah, likewise. Thanks for having me on.
Of course.
And remember, like and subscribe. Or else.